This is about some of what happened during the time that the the parties who had something to do with the master settlement agreement came together and reached some kind of conclusion as to what was going to happen uh, to, particularly in my case, to me, and what would happen to me after the master settlement became a part of uh, the acceptable um, degree of the states and the law, and that the money would flow from the tobacco companies into the states. And the first agreement, which was negotiated by Mike Moore, was actually in the hands of many different people, but principally it was an instrument that had been in the hands of Dick Scruggs and his brother-in-law to some extent, and the influential people in power, at least as far as the Senate went, John McCain. And um, from what I understand of that, the 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 whole idea was to create a remedy in in a short in a way to create a remedy so tobacco companies could escape entirely any kind of litigation. This master settlement was much higher, the first, which was Mike Moore's, and I think the amount of money in controversy was over $400 billion. The second came about in the same sense, and was in the neighborhood of $235 billion. What is intriguing about this is in looking at those those states that the Scruggs law firm and Ron Motley had, and to some extent the firm of Don Barrett and others, but particularly with Scruggs. Um, I had a meeting with Scruggs and his lawyers and my lawyer in 1997, and Mr. Scruggs came to the meeting with a formula for identifying how there would be compensation for, quote, the whistleblowers. Now, the only people that I could identify on my own, and having very close ties with this, the only people who actually did any whistleblowing in that sense, that might be in the same line of a qui tam whistleblowing, would be, I think, Jeffrey Wigand, who came late in 1995, 96, and certainly I came long before him. But in dealing with my own case, I know something about I know something about both. I know that in the case of Jeffrey Wigand, he sort of paralleled a lot of the things that, or he came into contact on the same level and at the same time, in many ways, quite different from me and what I encountered. Let me just say that in coming here and coming to Mississippi in as I did right after the Department of Justice had been rendered moot in terms of interviewing me in the fire safe cigarettes. I left and came under the encouragement of Dick Scruggs, and at that time, until the actual divvying up of what was to become the documents that would be referred to by Mike Moore as the infamous Merrill Williams documents in later arbitration hearings, I found myself, at least well after the point of being involved, pretty much left alone and to my own devices by all of the members of the Mississippi contingent, and certainly I never met Ron Motley, so it was not unusual that I would say, well, he's somehow connected, and certainly was connected at the hips with Dickie Scruggs and his law firm. But to go back to this meeting that I had at the close of the first arbitration, of the very first intent to settle the master settlement under Mike Moore's guidance. Dickie Scruggs met with me in a conference room in Jackson, and this as part of the history of what I'm doing here, was a meeting where I was represented at the time by Thomas Royals, who was a lawyer who was representing me, and as well was in the federal case for Dickie Scruggs and the John Does, who were most likely identified as what Atlanta wanted to find out, what in terms of their convenient obtaining of these documents, and then the distribution of the documents and so forth, for which I was the only one who ever had anything on the line in terms of representing what was happening in terms of depositions. I know that Dickie Scruggs and no one else ever was deposed on this matter, but for the matter of the meeting with Dickie Scruggs, there were at least 3 lawyers, and one of them I remember was named Carroll, and he was the principal lawyer of Scruggs and Jackson, and this was at a Jackson kind of a cushy law firm in downtown Jackson. And at the conference table, I was asked basically what I would be getting or needing, or what would be the resolution in terms of my own participation in this, or the lack of participation. Now, I had in mind nothing but a very simple cause of action in Kentucky, which had a figure on it, and that was pretty well under the direction of Fox DeMoisy. So he asked me the question. He was sitting at the corner down there. He asked me the question, well, what is your agreement with Fox DeMoisy? And that was it. And basically, Carroll came up to me because I had mentioned that I had been left basically in the cold, left alone for the years that I'd been here, which was virtually true. I don't recall anybody, except for the fact that I was given supposedly a safe house and it became less and less safe, certainly in the beginning, and then continued on. There's very little that was done in order to provide any kind of protection in that beginning, which we didn't know about what was going to happen. And certainly where my children were concerned and where bodily harm could have been part of it, there was every instance of a lack and a failure of a regard for any kind of protection or a kind of a means to make my life more comfortable. And in fact, in 1994, I can't think of any other time in my life when I was so miserable. And I think one of the reasons for that was the lack of attention and the sole disregard for my own person. And that was really purely up to and because of Mike Moore and Dickie Scruggs and the people at the Scruggs law firm. I can't complain, but it was certainly a bad time. And then it carried over in 1995, where when I got my second lawsuit, and believe me, it was directed at me, in the second month of 1995, I felt a lot more in jeopardy and a lot more attention to the facts that someone had been pursuing me, certainly as early as November, which I can identify, and that there certainly was an opportunity, much more so than in Louisville, because Louisville still had jurisdiction of everything. As far as the law was concerned, the documents and everything that had been initiated in 1993, this was carried over into the Mississippi contingent, which had no respect whatsoever for what had gone on in Louisville or for the law. And this was very clear to me. But after the years passed, and I had been totally ignored, so to speak, and the diva came in 1990, late in 1995, that being Jeffrey Wygant. And I remember one conversation with Scruggs, a very short, brief conversation, where he said, well, I'm going to be his lawyer. Well, that wasn't the first time we talked about Jeffrey Wygant. But the idea was that for some reason or other, he had offered me the chance for me to dump on Fox de Moisey, who brought me into this, and also Alan Morrison, who had brought me into this. And they were clean, and they had not been involved in any way in knowing something about the documents, seeing the documents, witnessing the documents, distributing the documents. It became a different case down here because obviously this was not a problem. Certainly not a problem for Mike Moore, the Attorney General, who authorized everything, and then later gloated about how in the arbitration proceedings how he had managed this, and how this contribution, at least the documents, the infamous documents, they were infamous when I had them. And then when they had them, they became famous. Well, this is his word, famous. They were infamous, according to him, while I had them, they were famous when he got them. And how they were distributed was still a mystery to me, even as I sat and looked across the conference table at Dick Scruggs, who at one point sent Carol over to me to discuss the fact that I had never been under an insurance program, even though I was getting $30,000 a year. I still was not given any kind of insurance, and for the reasons that I had discussed with my own attorney, that was one of the things that I was concerned about. No insurance. Dick Scruggs had just made $1 billion, or he was about to, or that was pretty much the case. on Mississippi, Texas, and Florida as part of his fees for the first part. And then he was to go on, and he had represented, for example, the state of Michigan, which I will talk about, and the arbitration on that in another tape. But what happened here was we were negotiating about what would be a solution to me dropping my lawsuits against Brown and Williamson, because Dickie Scruggs really didn't, there was no concern of his whatsoever. He considered me a mite in terms, or even worse than that. I mean, I can think of how the publicity surrounded the newbie who came aboard, who was obviously, you're going to trust somebody who's the CEO of a company than you are someone who takes away the evidence from Brown and Williamson, or therefore thereafter American Tobacco, which is part of Brown and Williamson. And so what was intriguing to me was how Carol could sit there and just wail on me about how Dick Scruggs didn't even know that I had no insurance coverage, that I was still, this was important. Oh, and if he had known, he had made sure that, this is just one part of the issue of protection, the concept of protecting a whistleblower. Well, the idea was also tantamount to that of Jeffrey Wygant. I mean, he seemed to be getting, we're not talking about just a place to live and a car, something to get around in. It's changing your whole lifestyle, but you're also walking into a very treacherous zone. And that's where I was by myself for a long time. And one of the issues that we had discussed and fully discussed I had discussed this with Scruggs very early on, was where's my insurance? Can I have some insurance so I can go to the hospital if I have to? And he knew this, and there was no question about it. He was a tricky man, and devious, and a scoundrel in so many ways. And yet he had no problem with the issue of disseminating these documents, and there was a coordinated effort to do so. When I didn't know this at the time, and how this happened, I certainly wasn't aware of. But anyway, this meeting, which took place in Jackson in the fall of 1997, was still under the jurisdiction of Mike Moore, and it was about to be changed, but for the most part, the idea was to get a resolution. And so after Carol discusses the various things about how he really wanted to that Dickie Scruggs was protecting me, and that there's Dickie Scruggs on the end down there, and I knew this was a lie, and I knew that most of this was basically self-serving, but Carroll was a pretty good lawyer, and so he could argue anything. Meanwhile, I'm looking at this very honest attorney that I have had. Not only honest, just downright good, and he saw through this, and maybe he had an idea of what was going on, because later on he was to make a resolution of some sort for me. But it wasn't the kind that Dickie Scruggs was talking about. At this time, Dickie Scruggs takes the floor. He stands up. No, he doesn't stand up. He's sitting there in the end of the table, far from me. And he, surrounded by three of his attorneys. And he says, this is what's going to happen. We're going to have arbitration panels. And these panels are going to award the whistleblowers and the only whistleblowers that I could possibly think about, and I'm not talking about the guy who came forth with the evidence about the rat experiments, because that certainly was not an interesting part of blowing the whistle. I'm not talking about Liggett, which came forth and said, "We want to save ourselves, please. You know, can we just let the others get dumped on and we won't get dumped on?" So that's not whistleblowing. And essentially the only thing I could think of in that time, and still can only think of, or two, and that is Jeffrey Wigand, who probably had something of a he was more protected because he was, they were going to make him what he was. They were going to create him in the image that they wanted, so he didn't have a problem. And he came in late, but he was always around and escorted by, I think, Lowell Bergman for many years, and that was the purpose. And what I found in that moment was that Dickie Scruggs was going to make a proposition about what was going to be the consequences of what I had done, and certainly to the extent that I was the only one I could think of other than Jeffrey Wigand, the whistleblowers. There was going to be a clause in the there was a clause. He was stating that this Merrill, this is what's going to happen. There is in the Master Settlement Agreement a clause which says that the whistleblowers will appear before or will be heard out at the national arbitration panels. Well, they already had the panel. They were ready for the panels. They knew how they were going to make the settlement for the attorney's fees, no question about it. And whether it was the first time or the second time, whether Mike Moore was doing the settling or whether Christine Gregoire was doing the settlement, it was still the same. The master settlement as changed, not by representing it in the Senate, but certainly the same thing in terms of what it was. Master settlement agreement with the 46 states and the Commonwealths and protectors, and then the 3 states that had already settled were all participants, and the tobacco companies and participating manufacturers. And so Dickie says, what you're going to realize here is that we will build this sum up. We'll build up for in the whistleblower area. We're going to build this up, and we don't know how much it's going to be, but I can guarantee you, you'll go. It could be 2 million, it could be 4 million, it could be 5, and then he stopped at 8 million. But that's, of course, the number that stuck in my mind, of course, and then to that effect, I think for about a year after that, this lay in the hands of as a contract, basically a contract, and at a minimum, you'll see. You'll see a minimum amount, but we're going to make you part of the arbitration panel decisions. Well, for Dickie, who was in the States, and Mike Moore was in the States, it was an incredible opportunity, and I realized that if the whistleblowers, and as I say, I could only think of 2, and certainly Liggett was not going to be in there as a whistleblower. And I don't think the Rat Man from Philip Morris was a whistleblower. I can't think of any other person. There were only 2. There's absolutely no way I can be wrong on that. It's just not. But in any case, that's what he said. You're looking at 8 million, and that's. So my attorney turns to me, and we leave the room after Mr. Carroll has somewhat agreed, and I had insurance for a short time. This was years after I came there and was left alone, totally alone, in 1994. Uh, Prior to the time that they gave me some attention in terms of what do you know, and when they got the documents, they absolutely stole the documents. There's no question about it. They disseminated the documents. There was no information that I knew how they disseminated them, except the ones that went to Congress. That I knew about. I did know, and I knew when they took those. It was on Sunday. And the real point is that Scruggs was making an offer. And not only was he making an offer, he was making a guarantee. Later, this was canonized as what appears in the arbitration hearings. Certainly in my take on Mike Moore's appearance, because Mike Moore was the one who went from state to state, and with Lowell Bergman, I believe, in the name of Jeffrey Wygant. And for some reason or other, this was all somewhat channeled into a silence. But I do have a record of that, so it will be interesting to make that part of this history of this dedicated to the profound reasoning that there was virtually a Mississippi Attorney General who was making trips to various states that was representing that were the states that Dickie Scruggs and his firm, so to speak, were in, and also Ron Motley, and wherever he went for lawyer fees, such as $450 million in Michigan, he would argue the basic points that he argued in the other states. But he was also the Attorney General of Mississippi, so I always wondered years after, when I was privy to this information, how did he do this? This is not exactly a state job. This is not part of his career job, but nevertheless, he did. And so I'll end on this note. There was an offer made. It was tendered in 1997 in the fall, and it lasted until there was a total lie that occurred, and I had pretty much decided that I would take this as a reasonable gesture and accept his offer. Only I was certainly saying, oh yeah, he's saying we're going to work for you, which incidentally is what they did. When they went Mike Moore and Dick Scruggs, and I assume the Rice law firm went around to places like Michigan. They took this information. They took Wygant. They took the information that they had on the infamous, which became famous when they distributed the documents. And this is somewhat of the mission that is so important. In other words, to collect money from the other states as well as the ones that had been represented here. But on a less significant note, there's no way in the world that you can say that you Dick Scruggs and your law firm and Ron Motley, whom I never met, and the Rice law firm, and certainly not Mike Moore, whom I saw twice, and I will give you my second meeting at one time at a later point in this history. And yet, this ended with the note that we would settle this, and we had settled it, so to speak, that for the first time I got insurance, which was part of what was agreed to very early in terms of protecting me. But there wasn't anything else out there that could be thought of as protecting me. No, and yet I feel that this was the best and the last time that I would think in good terms about any of the people who represented this terrible agreement, this master settlement agreement, and therefore the end was the beginning, so to speak. And the rest of it is an analysis of the Michigan Arbitration Panel decision and the dissent in that, which is coming up shortly when there's a little more light of us going.